Tonight, a new development in a former Belton High teen's appeal to overturn his conviction and 10-year prison sentence. Just a year after his sentencing, 6 News reporter Sydney Walker has the latest in Caysen Allison's legal battle. Sydney.
Allison's lawyers are appealing, but the state says none of their reasons warrant reversing the conviction, the deadly weapon finding, or his 10-year sentence. Caysen Allison's attorneys are appealing the former Belton High student's criminally negligent homicide verdict and 10-year prison sentence for stabbing and killing classmate Joe Ramirez. They argue 3 key mistakes happened in his trial. First, the appellant outlines jurors were never told they could consider self-defense for the lesser charge of criminally negligent homicide. Second, Allison's team says prosecutors failed to disprove Allison acted in self-defense, bringing up details from the trial, like Ramirez punching Allison first. And third, the deadly weapon finding. A jury never explicitly said a deadly weapon was used in their verdict. A judge did, and it wasn't during the trial, according to the appellant. 6 News spoke with legal analyst Liz Mitchell before the deadly weapon enhancement was approved. She explained the impact it could have.
There is an affirmative finding of a deadly weapon. The judge cannot give the defendant probation. So whether or not there is a deadly weapon finding in this case is critically important.
The deadly weapon finding took Allison's max sentence from 2 years to 10. But the Bell County DA's office says none of it holds up. They argue Allison's lawyers never asked for the self-defense instruction and say self-defense isn't compatible with the negligence charge in the first place. As for evidence, the state points out several counter details, like Allison bringing the weapon to school, allegedly planning a fight, and stabbing Ramirez multiple times. And on the deadly weapon issue, prosecutors say Allison chose to let the judge decide his punishment, and Texas law allows that judge to make the finding. The defense is asking for a new trial, an acquittal, or a new sentence without the deadly weapon finding. The Texas Third Court of Appeals has until July 20th to rule.